Good afternoon and welcome to the Lexis Nexis seminar on partners, workers, employees, the implications of recent case law. I'm Jeremy Callman, I'm your chair and one of the two speakers. I'm from 10 Old Square, my colleague Jonathan Gavaghan, also from 10 Old Square, and we're going to talk to you in this webinar for the next hour.
We're going to talk today about traditional partnerships on the one hand and limited liability partnerships or LLPs on the other. Now, traditional partnerships are partnerships covered by the Partnership Act of 1890, and that means that you have two or more people carrying on a business in common with a view to profit. And the key, certainly I think for today's purposes, is that there's no separate legal entity when you're dealing with a traditional partnership, at least in England. You just have a collection of individuals. Now, while we talk about a firm, the firm doesn't have a legal identity. It's just, as I say, a collection of individuals. Partners share profits and are jointly personally liable for all losses or debts of the partnership. And that personal liability is unlimited. And those are the sort of people that we'll be referring to as partners, whether they be equity partners or sometimes referred to as true partners. Traditional partnerships governed by the Partnership Act of 1890, and there may well be, obviously there's case law on that, and there's also may well be governed by some sort of contractual arrangement between the partners, which may be in a partnership deed or agreement. So that's traditional partnerships. On the other hand, there are limited liability partnerships. Now that's a relatively new concept, brought into existence by the Limited Liability Partnership Act in 2000, been very popular, especially for professional services firms, law firms and accountants. And the key advantage is given away in the name. It's that you have limited liability. And that, involved in that, is one of the key legal differences that we're going to be occasionally addressing today, which is that the LLP has its own existence, separate from its members. So it's a separate legal entity, it's its own person, if you like, and it's a body corporate registered at Companies House. In the same way as a partnership is often governed by a partnership deed, an LLP will normally have a members agreement. And we're going to return later in this seminar to the effect of some of those differences has for various topics that we're going to look at. Now, LLPs. There's obviously a substantial overlap with traditional partnerships, but you do have to be aware of a different dynamic. Now, we've already mentioned in a traditional partnership, all the partners owe each other fiduciary duties. The firm has no legal identity, so there's no third party for which partners owe a duty to other than themselves. So that makes, in one sense, it quite straightforward. The difference, though, with the LLP structure is that because the LLP itself exists, you have a sort of at least a tripartite arrangement with the LLP and the members underneath it. And it seems to me quite right that if you have an LLP and you have a normal sort of carrying out, a solicitor's firm, and a member carries out work on behalf of the LLP, then that member will owe the LLP a fiduciary duty because it will be doing something on its behalf. And that Section 6 in the LLP Act has a similar provision about acting as an agent. So that member will owe fiduciary duties to the LLP. But the question becomes more vexed when you ask yourself about the relationship between the members rather than going up the chain, if you like, between the member and the LLP.
On to expulsion and compulsory retirement, the nasty side of partnerships. This is where the tensions start getting really strong and where feelings start to flare. Bear in mind what's going on here. We're talking here about somebody being kicked out of what is essentially in part their business. So emotions are strained and often you have to make some quite difficult tactical decisions as you go along. I think the most bizarre situation I had in that context was when I got a phone call from a managing partner to say they'd told one of the partners that they were going to expel him, and he had barricaded himself in his room and had told the other partners he had enough food and water, and apparently there was a toilet built in, thankfully, to his office. He could last for at least 2 weeks, and they wanted to know whether they could cut the electricity and heating off to his room and starve him out. So it really gets fairly unpleasant, but we're going to look at the legal context and some of the key principles surrounding this. There are 4 things that you'd want to be thinking about. The first of them is only relevant in the context of expulsion for the reasons that should be obvious from the explanation. In other words, is the ground made out? So if you've been expelled, for example, because you have said to be acted dishonestly, and that is in the clause for the expulsion as a ground for expulsion. That is a matter of fact and law as to whether you have or have not behaved dishonestly. So that ground has got to be made out by the firm seeking to expel you. And so that's for expulsion only, where you need a ground. For both expulsion and compulsory retirement, you've got to follow carefully the correct procedure. So if the clause specifies a period of prior notice, if it says you have to have a meeting, it has to be voted on, you need a certain percentage vote approving, all of that has got to be complied with carefully. Then thirdly, there is the possibility to attack both an expulsion and a compulsory retirement on the basis of bad faith. In other words, you can say that it was done for ulterior motive and it should be struck down. It's a fraud upon the power, if you want to use 19th century language. And finally, for both expulsion and compulsory retirement, they can be attacked on the basis of discrimination. And that's all now set out in one convenient place, namely the Equality Act 2010, which brings together a multitude of different previous legislative regimes, and you can certainly, if you can show that the expulsion or compulsory retirement has been done on a discriminatory basis, the court can strike it down on that ground. Okay, procedure. If you want to expel or compulsory retire someone, follow the procedure with great care. It is a blinding reality that Jonathan and I probably see regularly, which is that many firms, many partners have not really looked at their partnership or LLP agreement for some long while, and sometimes never. Even if they're lawyers, that's sadly the case. But if you are looking as a firm at wanting to get rid of somebody, you definitely want to pull it out the drawer and have a careful look through the procedure and make sure you follow it. And that's notice periods, that's how the notice is given, and all of those things. So follow your procedure. Interesting question, should you give an opportunity for the partner who's up for the chop, or potentially up for the chop, to have a right to respond, a right of reply, as it were. If the partnership agreement or LLP agreement actually expressly says that they should, again, you must follow it. Assuming for a moment it is silent on that question, which is often the case, then the firm is faced with a choice of, do we give that partner or member an opportunity to reply in any event? Now, in my view, that's often a sensible thing to do. Firstly, they may actually provide a real answer to the allegation. So, for example, if you're proposing to expel someone for having stolen money from the firm, and you say to the partner, you know, we are missing £10,000, you have taken it, and the partner turns around and says, no, I haven't, it's in a different bank account, in that account, not that account, well, plainly, you're going to look extremely stupid as a firm if you then start going down the expulsion route. So there might be an answer, genuine answer to the allegation. But more than that, there are, it seems to me, issues of natural justice at play here. And whilst the case law doesn't really go down that line as yet, it seems to me that there is a possibility that it will develop in that way. And also, perhaps more importantly, it does seem to me that it feeds the impression of a kangaroo court if you don't give the partner an opportunity to reply. So given that you're trying to guard against bad faith, it seems, in my view, sensible, therefore, to say, right, well, this is what we're proposing to do, and what have you got to say about it, and we will circulate what it is that you have to say to the other partners so that they can take that into account in deciding whether or not to exercise the power. What are the consequences? The traditional view of the consequences are that if you succeed in establishing that the expulsion or compulsory retirement was invalid, the effect is that it's as if you had never been expelled or compulsory retired because the act was an invalid one, and therefore you go back, you're put back into the position that you would have been in but for the purported expulsion or compulsory retirement. Now, in real terms, that means you're effectively paid your missing partnership share, profit share, in the period where you've been treated as if you had been expelled or compulsorily retired. On top of that, dropping down to the third of the bullet points, there is some suggestion actually that you might be able to get some form of damages even on that analysis. That's Mullins and Lawton looks at that, although it's not a decision on the point, it's a decision that it's arguable, and that in particular drawing on the BCCI litigation in the employment context, The judge said that he thought that you might be able to recover damages for career disruption and damage to your reputation. The middle bullet point takes an interesting point, and this is something that's been bubbling around in recent case law. A very recent decision again of Mr. Justice Warren, another large decision, the IBM decision, and that builds on earlier decisions in the Court of Appeal and the Supreme Court. And that raises the question as to whether or not the wrongful act, here the wrongful expulsion or compulsory retirement, might end up being voidable rather than void. And that's a bit of a techie point, but the practical upshot is that if it's voidable rather than void, then it's effectively up to the individual who's the victim of the wrongful act to decide whether or not to treat it as terminating the arrangement. If they do, arguably then, could they then say, right, we are suing for damages, or I am suing for damages. So query, could you use that new line of authority to try and argue for damages rather than to be returned to the position that you would have been in on the basis that the wrongful expulsion or wrongful compulsory retirement is invalid. It's a very interesting and evolving area of law.